Thank you so much for being here tonight. This is an awesome turnout. I'm Kate Heinen, with co-chair for Women's Equality Coalition of Greater Kansas City, with Stacy Webb, other co-chair. I'm also the coordinator of community engagement with MOXA, the Metropolitan Organization to Counter Sexual Assault, and a local social worker. And Women's Equality Coalition, we focus on voter rights, gender equity with pay equity, and violence against women, and people who identify as female. And so we've historically done a really packed week in August that you've probably attended, and we're trying to kind of space out our events and also support other coalition member organizations who have their events as well. And so this was one that we were fortunate enough to organize and have AAUW as a great sponsor for. I'm going to go ahead and introduce Mary Sanchez, who's going to moderate tonight's panel. And I also want to point out, too, I'm sure Mary will also say this, but in Kansas City, I feel like we're really, sometimes when you do a lot of organizing, you get hung up on who can we bring in from the outside. And I think we have just a ton of local experts and just brilliant people here in Kansas City who can talk on a lot of, just a wealth of knowledge and can talk on this topic. And we don't have panels like this frequently enough. So super excited for tonight. I'm going to introduce Mary. So Mary Sanchez is a nationally syndicated columnist with Tribune Content Agency, specializing in Latin American issues, immigration, race, politics, education, and culture. Her columns appear in publications across the nation and internationally. She was a 2019 Quattrone Investigative Reporting Fellow with the John Jay College of Criminal Justice, and she has also been a Metro columnist for the KC Star, and a member of the Star's editorial board, in addition to her years spent exploring race, class, and educational issues through enterprise reporting. Her work has been recognized repeatedly throughout her career by various entities at the local, state, and national levels. I know that I'm always thrilled as someone who works in the violence against women field to see that an article comes out by Mary Sanchez. She's lived in Mexico and traveled extensively in Central America and is a native right here to Kansas City. So take it away, Mary.
Okay, I'm told this is just fake. It doesn't work, so. Thank you so much for coming. I'm actually kind of glad that it's, not an overwhelming crowd, because I think some of these issues, get to a lot of emotion in workplace and what women go through. So, the chance to have kind of maybe a more intimate conversation with people, maybe people will feel more open to be able to, speak out, because this is granted we're filming here, but I mean, it is somewhat, I think, a welcoming, safe place to have these conversations. As someone who started working, technically when I was 11 to save for college, I mean, when I think back, there were a lot of things that occurred even in my lifetime. So I'm sure a lot of us have a lot of experiences, and, if you're a man in the crowd, perhaps it was your wife, your daughter, or another coworker. So we're kind of, we're all in this together, I think, to figure out some answers for, sexual harassment and gender discrimination in workplaces. And with that, I would also concur, yes, about the panel that we have. I've been pleased to know many of the people that are on the panel in, prior reporting, and I would totally agree with that comment that we have so much experience here in Kansas City and a lot of people that have already done a lot of good work. So I'll just say kind of briefly who they are, and then we're going to have each of you come up and give kind of like your remarks in terms of just setting a tone on the type of things which kind of more your expertise area that you want to talk about. And then we'll open it up to some questions. We have some that are prepared, but frankly, again, since it's a bit of a smaller group, what I generally tend to like is I want to, answer the questions of the people that took the time to come, to show up. So if we have enough questions from the crowd, we'll kind of let things flow that way, just to feel like, so that you feel like your time was well used. Okay? All right, so I'm going to go down just the list as it is on your flyer here first, and then we're going to change it up a little bit in terms of the order that we have people speak. But Judy Ancel is going to be speaking on labor rules and protections. I go back years with Judy, and frankly, if I needed to know anything about Honduras right now, she'd be the first person that I would call, or about labor rights history in the U.S. and globally, and just what is going on right now in the courts on labor rights. She would be my point person, hands down. Then we're also going to hear from Athena Dickson, and she's going to speak about arbitration and non-disclosure issues. And you've heard about non-disclosure issues quite a bit in the press recently, and I think coming from, someone who's a plaintiff's attorney, you can answer some things that you have dealt with, some of the things that are so misunderstood. It's a huge open area, which I know you all know. Next, then we have Kim Lawson, and she's going to speak on sexual harassment and wages. And Kim was with the organization that you guys probably all have heard a lot about, Stand Up KC, Fight for 15 for minimum wage. And she's also a representative of the Fannie Lou Hamer fast food workers. And I would say, I'm trying to remember if you were there the night I was there. I spent a couple nights at the church with your group, and I just tell you, I tell people about it sometimes. I was so moved by the work of your group. It's to be commended. And that's, everyone knows that Stand Up and Fight, and I don't think they know enough about the Fannie Lou group, but it's a group of women who are sharing their experiences and learning about organizing. You'll get it done. I really believe you will. And then we're also going to have Jane McQueeny, and she is chairwoman of the, or chairperson, I guess I should say, of the Kansas City Human Rights Commission. And she's going to talk about just the process of filing the complaints. What do you do? I think a lot of people get, you have experiences, you know that it was wrong, but how do you move forward from that place to not be the victim, to be your own advocate and to find your allies and to go through the legal process? So that would obviously be another topic that we need to cover. Okay, I think we're going to have Athena Dickson start. Right.
Good evening. My firm represents employees in cases of employment discrimination, specifically when you've been discriminated against because of your age, race, sex, national origin, disability. We've been working in this area for many years, and I've taken an interest in sexual harassment and gender discrimination cases for many years and have helped multiple women through the process. And a lot of the questions that we get is, how do we proceed through the legal system if we have claims of sexual harassment, or when we bring those claims up, if we're terminated because of reporting our claims? And so what I'm here to talk to you this evening about, and I'm happy to take questions if any of you have them while I'm talking, is the arbitrations and how arbitrations work. So employers and companies tend to use arbitration agreements as a way to avoid litigation and jury systems coming in and giving verdicts for employees. And so arbitration agreements, an arbitration is where one person hears about a legal dispute and makes a decision on it, as opposed to when you were to go to trial and you have a jury of your peers that would make a decision on it. So there are reasons that companies use arbitrations to resolve disputes. I believe the biggest reason that they do that is because there is a larger probability of avoiding big jury verdicts. An arbitrator is one person, usually a lawyer, that hears all of the facts and makes a decision, and you don't usually get the ability to appeal that decision. And so from a company's perspective, and the last thing, more importantly, is that it's typically a confidential proceeding that's just between the parties. So there isn't media that's involved. There isn't anyone sitting through and listening to all the facts of an arbitration. So arbitrations have been and are being enforced against employees in the state of Missouri. So you think, how do I know if I'm going to be subject to arbitration if I have claims that I would like to bring against my employer for sexual harassment, retaliation? You do know, but sometimes it's easy to overlook. Most of the time, the process of agreeing to arbitration agreements happens either at the application process or at the onboarding when you're filling out all of the forms that you fill out to start a new job. There are a couple of things that you want to remember when you're starting a new job and if you see the arbitration. One is that you don't have to sign it, but they don't have to employ you as well. So the consideration is employment. That puts an employee in a very tough position because you've accepted a job, you're starting a job, you're going to agree to the arbitration because you are going to move forward with the position. I think that something that you should think about looking for, though, if you see the arbitration, is sometimes there are opt-out provisions. And an opt-out provision is where you say, no, thank you. I do not want to be involved with the arbitration process. If you have the ability to do that, you should review that information because there usually is time periods that's associated with that, and there's a process. It's not necessarily very easy to opt out, and you don't get to say, okay, now I have a dispute, I'd like to opt out. So be aware and know that if your company has an arbitration policy, know what it is, look at it, and make sure you keep a copy of it in case a dispute were to arise related to that. You would know what the process would be. Another question that we often get asked about arbitration agreements is who decides whether or not it's going to be enforced against the employer, against the employee. And usually a judge makes the determination on enforceability. Some things they look at is, did you have to sign it? Did you have the ability to opt out? Did you ever actually see the document? How visible was it? Did you know what you were agreeing to? Was it really a contract? But the judge makes those determinations typically on that situation. And in Missouri, there are a lot of arbitration agreements that are being enforced. So I'm not sure that it's anything that's necessarily going to change in the immediate future, but there are some things that you can do and know your rights related to arbitration. Look and see if there's an ability to opt out of that agreement. And you can also encourage legislation that limits or eliminates arbitration policies. And there's businesses that are now coming out and they're saying, we're going to rescind our arbitration agreements. So when you see that, that would be something that you want. I mean, that would be the way that we can stop arbitrations from being forced onto employees. The other, I would also like to talk to you about NDAs. It's been in the news a lot lately. We call them usually confidential settlement agreements in the legal world. So what is the purpose of keeping settlements confidential? Typically, it's an agreed upon term in most settlement resolutions. So if you were to bring a claim against your employer for sexual harassment, retaliation, any kind of those claims, you would usually either go to trial, have an arbitration, or resolve the case. There's a statistic that over 90% of cases are resolved through settlement. If you resolve the case, and most of the time in employment cases, when you resolve it, you have confidentiality associated with it. Now, what does that mean? It means that most of the time you're not going to talk about the facts and the underlying claim or the amount of money that the company pays you to resolve. I think that's incredibly unfair, and why would that be the case? It is unfair in some ways because companies are allowed to continue victimizing other women through sexual harassment, and there are many reasons it should be considered, and confidentiality should not continue on. One thing that hasn't been discussed about in the media as much is the victims of the sexual harassment, though. The confidentiality also allows them not to have to go out and answer questions and talk about something they would much rather put behind them and be able to move on with their life. So, I mean, I think the confidentiality, there's pros and cons to both of it. I think we talk a lot about the cons, and I think that is a real reason. But I do think as well, when you saw in the news lately about Bloomberg and the issues that he was being asked about, there's two sides. You need to make sure this is a contract that they've entered into. Both parties have to agree to change the terms of it. So as far as non-disclosure agreements go, it's a contract. There's two parties. The company is usually one, and the victim of the sexual harassment would be the other one. And so before you change any of the confidentiality terms, both people need to agree to it. Most confidentiality agreements, they last forever, in perpetuity. And I think that as far as if this is something that's going to continue, there will probably be confidentiality will exist as far as employment agreements go and settlement agreements, but there are things that we can all do to make sure that if we go forward with claims, we want to try as much as possible to be sympathetic to victims, to not persecute them if there is a newspaper article or anything that's discussing claims. And we also, as we're dealing with these situations, you have to understand that sometimes you do agree to confidentiality because the alternative is you have to go to trial and you risk losing your case. And when we settle, you have control over that, and you dictate the terms of what happens to it. And for a victim that has been through sexual harassment, they don't necessarily want to relive it in front of a jury, and they have concerns about what then would happen if they lose that. So I think that it's not necessarily something that's going to go away, but it's something that we should all understand that doesn't necessarily only benefit the employer.
Yay. Okay. Great overview. And I'm sure that you'll have maybe some follow-up questions, and even it sparks in my head to have to mention, one of the things that is occurring more and more with media, with the consolidation and, the struggles of particularly the Kansas City Star, frankly, in the staff is just so much shorter shrinkage than it ever was before, is that there is a lot of mining of lawsuits that we never used to do. I still say we with Kansas City Star, I was there 33 years. So if you file a lawsuit against a company that is well known, it is a fair warning that, because it's an easy story to write, frankly. All the allegations are out there, and it's a he said, she said, and you can put it out there. So that's a real concern that I don't know that it would be interesting to see, even though we had so much more staff before covering things, like a giant business staff, this looking for lawsuits to write about is happening pretty frequently. So that's another whole aspect of how, someone would make an allegation or frankly feel like they were re-victimized. But once you put something out there as a public document, that is what it is. So, and just to your points about the confidentiality, it is a protection somewhat. Okay, next, we really want to hear from Kim Lawson, and she's going to speak about sexual harassment and wages.
Good evening, everybody, and thank you to the Women's Equality Coalition for inviting me. My name is Kimberly Lawson, and I work at McDonald's. I'm here to tell you that McDonald's has a sexual harassment problem. The $200 billion fast food industry I work in, where 2/3 of us are women, has a sexual harassment problem. And I even believe that America, our great nation, has a sexual harassment problem. Finally, we are beginning to do something about it. Back in 2018, when the Fight for 15 and a union movement made a historic alliance with the MeToo movement, myself and other McDonald's workers across America joined together with the Time's Up Legal Defense Fund and filed sexual harassment claims against McDonald's. Since then, we have also partnered with the ACLU because more and more workers across the country have come forward to sue McDonald's. Like me, they are suing McDonald's because they too have been sexually harassed. When will it be enough? When will we put a stop to this widespread problem? I can tell you, every time another woman comes forward and tells her story of sexual harassment, it breaks my heart. And the fact that so many McDonald's workers continue to come forward just proves how deep and rotten the culture at McDonald's is. Working at McDonald's is hard enough already. I only make $9.45 an hour, and it's a struggle just to afford stable housing. I don't receive any health care benefits. I don't get any paid sick days or paid vacations. I often have to donate my blood plasma just to make a few extra dollars to pay my electricity bill. I am a single mother of a beautiful 5-year-old girl named Faith. Survival for me and my daughter is a daily challenge. I should not have heaped upon all of that, the heavy stress of sexual harassment. No woman should. When I started at McDonald's 4 years ago, there was no mention of sexual harassment trainings, no mention of sexual harassment policies, and no mention of a phone number to call if we experience sexual harassment. McDonald's, a multi-billion-dollar company, does not seem to care. I hope that by coming together to tell our stories, we can force it to care. Here's my story. I have experienced harassment at McDonald's, not just once, but twice. In the fall of 2017, a manager repeatedly made sexual comments toward me. He talked about my body, including telling me I had a nice body and a big butt, and telling me to leave my boyfriend. Because he was a manager, I felt trapped. I felt like I had no choice but to tolerate it. Though I rejected his advances as politely as I could, over and over again, they persisted. The only way I could avoid them was to try to rearrange my schedule so that I would not see him at all. So I actually lost hours off of my paycheck that I desperately needed for me and my daughter, just to be able to feel safe at work, just to stop being harassed. I want you all to take a moment to step into my shoes. During this time, I was homeless, going from place to place, staying with friends and coworkers. I eventually ended up in a homeless shelter. I'm riding the bus back and forth just to keep my job, but I'm having to worry about either losing hours at work or being unsafe at my own job. No woman should have to make a choice like that. I have also experienced harassment from a coworker. He used to stare at me. He would stand uncomfortably close to me. He would brush up against me and even touch my butt. He would give me gifts which made me feel uncomfortable. I reported his behavior to the general manager, but nothing was done. No woman should have to experience what I experienced. That is part of the reason why we are fighting for union rights. No woman should have to experience what I experienced. That is part of the reason why we are fighting for union rights. I felt like I need to say that twice. According to a 2017 study, 4 out of every 10 female fast food workers report that they have been sexually harassed on the job. That's why women need strong organizations on our jobs. We need a union. We know we are stronger together, and with our union, we can have the strength to protect one another and demand the justice we all deserve. I'm here today to tell you my story for a few reasons. First of all, I want my daughter to know that I've done everything in my power to make sure that she never has to go through the things I have gone through. Secondly, I want to tell you that there is a lot that you all have the power to do. McDonald's is the second largest employer in the United States of America. They are the second largest employer in the world. If we allow them to continue to get away with paying us poverty wages and sexually harassing us at work while they do nothing about it, what will that lead to? McDonald's is more than just a leader in the fast food industry. As the world's second largest employer, what they do has a ripple effect in our economy and our culture. Together, with workers and people in community organizations like yourselves, we must build the collective power to force them to change the culture of harassment and exploitation at their stores. We must force them to actually respect the needs and the voices of workers like me. by sitting down at the table and negotiating with us as a union. If they don't hear our experiences, if they don't respect our voices, then this problem will continue. And winning a union is a way for workers like me to be able to have a voice and a say-so to fix these problems. Thank you.
Thank you, Kimberly. I think you can tell your daughter you've already met that challenge that you set out there. I mean, you've already accomplished something just by sharing your story. I think a lot of us, you know, either if we haven't ever worked in the fast food industry, you actually did, or you forget and don't realize what it's like for people now, and particularly a lot of them are women. So, okay, next then. What should be the rules? Labor rules and protections. We'll hear from Judy Ancel.
Hi, everybody. Does this work?
No. Yeah,
No?
No, it's working for me. I need it for this.
It's working for you. Then I won't dump it. Okay. Well, first off, thanks to St. Paul's. Thanks to Alice. Thanks to everybody who worked on organizing this thing. And thanks to you, Mary. When Mary left the Star, I was very disappointed because she was accessible as a reporter. And I knew how overworked she was, too. And I really feel for the people who are left in print media because they are truly overworked. And the stories we miss because there isn't anybody to report them is something that 100 years from now, historians are going to say, what the heck happened? Why is there no record of all this stuff? It's a personal pet peeve of mine, but anyway. So I am going to talk to you about labor law. And, you know, the first thing I'm going to say is probably the most significant. Labor law in the United States sucks. Okay? We have some of the weakest labor law of any developed country in the world. Now, why is that? You know, basically, labor laws are as good as people are organized. And Americans are not very well organized. Today, only 1 in 10 workers belongs to a union. And that just doesn't give us the bargaining power to be able to make our employers accountable. And they get away with what you just heard and a whole lot more. How many of you are union members or ever have been union members? Okay, good sampling. More than 1 in 10. That's good. How many of you may not be union members, but you have a job where you have a contract? 1 of you, 2 of you, 3 of you. Yeah, that's pretty rare, and it's usually for professionals, especially baseball players, actors, and so on and so forth. The rest of you, if you're working or did work, were what is called at-will employees. You had no job security at all. And one of the greatest misconceptions about labor law is that you have rights. Nah. You can be fired, if you're an at-will employee, you can be fired for any reason or no reason. You could be fired because you're wearing a necklace that the boss doesn't like. You can be fired because you go to the bathroom too much. You can be fired for any reason at all. Or you can just be fired because that day the boss had a bad day. Okay. That's why the sorry state of labor law in this country is the way it is. Every state except for, I think, 1 has at-will employment. And so most of our workers work at will of their master. It's more like slavery. So let me talk just a little bit about what rights you actually do have, because you do have some rights. It's not all that bleak. Okay, first off, you can't be fired because you're a woman, a racial or ethnic minority, disabled sometimes, over 40, if you can prove that that's the reason they fired you. Big if. Okay, now, Kimberly's been discriminated against. How many of you women here have been discriminated against because you're women? How many of you actually went and tried to exercise your rights? Ooh, big difference. I lost a job at one of our local community colleges because somebody on the hiring committee said I was a ball buster. Me? Heavens, no. Did I go, exercise my rights and ask the EEOC to go investigate that college? Hell no. Why? Because I never would have gotten another job in any community college in the area. So you don't do it. That's a really weak law. And they get away with a lot. But anyway, that's one right you have, okay? Another right you have is you have the right to overtime after 40 hours of work in a week if you're not exempt. Okay, now a whole lot of people are exempt. Under the Obama administration, we tried to raise the cutoff for making people exempt to about $40,000 instead of the current $26,000 or $27,000 it is, where an employer can just say, oh yeah, she's exempt. And then that got defeated. That got defeated in the courts, and then the Trump administration, of course, abandoned all that because they are very anti-worker. So you do have the right to overtime. Hooray. They can force you to work, though. So you have kids at home, you have child care issues, they can still force you to work because we don't have a right to refuse overtime. Okay, you have the right to unionize if you're not a boss, right? And there's a lot, but, like supervisors, there's a lot of people who are called supervisors, and my joke is, I had a student once who worked at McDonald's, and he said he just got promoted to be a supervisor, which means he lost his labor rights. I said, so what do you do that's different now than you did before? He says, I get to count the French fries. It's a title. He probably got a little extra money, but he didn't really get any power. But he lost his rights to unionize. Okay, supervisors once did try to organize in this country, and they immediately passed a law and said, no, you can't do that. That was the Taft-Hartley Act, 1947. You have the right to be paid for what you do. So if you work, you have the right to be paid, at least minimum wage. So what's minimum wage these days? Anybody know minimum wage? What? Thank you. $9.45 in Missouri. Why is it higher in Missouri, Daniel?
Because of a state law that raises the minimum wage.
Right, because a whole bunch of people organized, and we forced it onto the ballot because the legislature wouldn't do that. Why is the federal minimum wage still $7.25? Anybody know? Congress won't raise it, right? They haven't raised it for over 10 years, right? Because we don't have the power nationally to force them to do that. By the way, next year, the minimum wage in Missouri is going to go up to $10.30. And eventually it's going to go up to $12, which is great, except it's still not enough. Okay, so that's another right you have. That is if you are not misclassified as an independent contractor, which many workers are. The boss says, oh yeah, we're not going to hire you as a regular employee, we're just going to pay you as a contractor. That happened to anybody here? Yeah? Yeah, were you really a contractor? Okay, yeah, carpet cleaners who work for, companies and they only work for that company get classified as independent contractors even though they're using the company's machinery and equipment. They get scheduled by the company. They never work for anybody else, but they call them independent contractors, and they don't have to pay them minimum wage. They don't have to pay their taxes for them. They don't pay Social Security, or they're responsible themselves because they're, quote, independent business people. It's one of the most violated labor laws there is. Leads to lots of wage theft. Okay, and then you have the right not to be killed on the job. Hey, don't laugh. That's a serious right. You actually have the right to refuse dangerous work that could cause you death or harm, but you better be able to prove it. Because if you refuse it, the work, and in fact it wasn't that dangerous, some judge may say, then no, you don't have the right, okay? You have the right to be compensated for injuries on the job if they're the employer's fault. When you start sharing fault, it gets a little dicey. Okay, so I want to talk about one law that most people don't even know about that they have. Back in the 70s, I worked in the electronics industry in California. I worked for a company called Litton Industries, which no longer exists. It got bought up by somebody else. They were famous for their microwaves. And I worked in a factory that had a clean room, and we worked with a lot of chemicals, and it was really bad on your eyesight because you work with microscopes and all that stuff. Anyway, they never said how much people were paid. And one of the first rules they told me was, my boss told me was, never talk to anybody about how much you're paid. First rule I broke, okay, being the troublemaker that I always have been, I started asking people, how much you making? You know, and I found out that our wages were all over the map. And word got back to my supervisor that I was doing this. And he would take me aside, and he would very fatherly, because I was fairly young then, you know, put his arm around my shoulder, and he'd say, hey, I told you you're not supposed to talk to people about wages. And I said, oh, okay. This happened about 5 times, okay? And I always wondered why he didn't fire me, because I didn't know my rights. Turns out I had a right to talk about wages, and the boss cannot tell you you can't talk about wages. And I found that out later. I said, oh, that's why he didn't fire me. Okay. You know, so the deal is this. Under the National Labor Relations Act, which if you are an employee and not a supervisor, you are covered by. There's a thing about what size company you work for, but I'm not going to go there. Under that law, you have the right to what's called concerted activity. Concerted activity means that you and some other person have the right to talk about your wages and working conditions. Because that's the first thing that happens before you organize, and that law gives you the right to organize. So if you're working in a place and management has a policy saying you may not talk about wages or salaries, you have every right to say, yeah, no, I'm going to talk about them. You have the right to do it publicly. They may try to fire you, but you have a right, and you can go to court, and you can get your job back. So broadcast what people make, because the thing is, who does it help to keep wages secret? Who does it help? It helps the employers. You know, but it's really funny because I worked at UMKC. You know, I tried asking people how much they made there. Oh, that's personal. You know, I get this from women who talk about their sex life, but they don't want to talk about how much they make. Too personal. And, you know, I mean, it's not just at that workplace, it's, you know, a lot of workplaces. People somehow think that it's embarrassing if I tell you that how much I make. Maybe you make less than me, and you're going to feel competitive towards me. Maybe you make more than me, and I'm going to feel really bad. Because the boss doesn't think as much of me as he does about this other person. It just keeps us divided. and it keeps us from getting together and figuring out we have common problems. So I guess I'm probably over time, but I'll leave it at that. There is, if you want to ask some questions, I also can talk about some other labor rights we don't have, which could become very, very important in the next few months. And they have to do with our rights to sick leave and our rights if there is a shutdown of the economy because of the COVID-19. But I'll leave that for Q&A. Thank you.
Well, the candid comments, and actually that could be, I have to do a thing for IRC on COVID, and I'll mention that because that's a whole other point. I mean, as, you know, not to fearmonger or anything, but as we are possibly entering into a different area for us. One of the things that also, you know, I know that we don't have in the entire evening, but, you know, even to see a little, I would like to hear somewhat from, you know, the businesses side of this, because one, it's, you know, the reason why media always talks about transparency is to, you know, raise all ships, that it does the light of day, you know, helps out everyone. I mean, and if a workplace really wants to have workers who are performing at their highest level, you would think, I mean, if we could actually get to a place in the U.S. where people felt that they were being honored and treated well, ultimately you would think that it would help out everyone, including the employers who, at this point, are the ones that are possibly causing some of their own grief, inadvertently or not, and having to have big settlements. So,
We need to go to Sweden.
well, there you go. But we're in Kansas City tonight, so. Anyway, okay, so finally then, and then we'll go into some questions. We wanted to invite up Jane McQueeny, and she's going to talk about, you know, your resources, just how and where to file a complaint.
Well, I will talk, but not very long, because I want to hear what you all have to ask about. But just quickly, a couple of things I wanted to mention. I am with the Kansas City Human Rights Commission. It's a volunteer job. I'm appointed by the mayor. I was appointed by Mayor Funkhauser in 2007, and I've been on the commission ever since. Mayor James appointed me chair when he became mayor in whatever year that was, and I've been chair ever since. So, and with me tonight is Paul Pierce, who is an investigator with the Kansas City Human Rights Commission, or Department, the Kansas City Human Rights Department, and they investigate complaints of discrimination. So if you want a firsthand view of what you go through when you file a complaint of discrimination, Paul does that for the Kansas City Human Rights Department, and they have a work share agreement with two of the major agencies in Kansas City, or in our state, the Missouri Commission on Human Rights and the EEOC, which is the federal agency. So a couple things I just wanted to add on to some of the things I heard up here. You all have probably heard about the Tax Cuts and Jobs Act. Everybody familiar with that great piece of legislation? Probably not. But one thing it did do is sort of out of the MeToo movement was there was a codification to the Internal Revenue Code 162J. Wow, this is fascinating stuff, right? It is, because what it did in the past, and from the business perspective, this was a big change. You'd go in to mediate a confidential or a sexual harassment case, and they'd say, "We want this closed up. We don't want you talking about it." And as a plaintiff's lawyer, I always said, "Okay, you want my client not to talk about this? Then you got to pay us some extra money." And they were always like, "No, we're not paying you extra money. Your client doesn't." And so they kind of know, and they prey on that vulnerability that plaintiffs don't really want to talk about it. So anyway, 162Q of the Internal Revenue Service says now, if you have a sexual harassment case or a sex abuse case, and the employer wants you to sign a non-disclosure agreement, it is no longer tax deductible for the employer. Big change in the law. So in the past, if I paid a sexual harassment lawsuit, say it was $250,000, $300,000, I got to deduct that as an ordinary and necessary business expense. in addition to my attorney's fees, I also got to deduct those attorney's fees. So now, with the Tax Cuts and Jobs Act, 162Q, you can't make that deduction anymore if you have your plaintiff sign a non-disclosure agreement.
Is that the tax law, though, that the Trump administration just...
It is, but how it got through Congress was because there was a give and take at the passage of all legislation, and this was right in the crux of the MeToo movement, the Harvey Weinstein, all of those big cases. And so the Democrats said, hey, you know what, you want this Tax Cuts and Jobs Act thing? You've got to give us this codification to the Internal Revenue Service. So if you're advising or you're in with or you are a plaintiff, know that now you really do have a little bit more leverage if they want to know non-disclosure, because they're looking at giving up major tax deductions. So that's something to know, especially if they're a smaller company and they pay $175,000 on a settlement. They've just lost a big deduction. So I just wanted to add that. Let's see, what else did I want? I want to say something great about Kansas City, because Kansas City has Alice and Gail, and last year, with their leadership, the Kansas City Human Rights Commission and the City Council passed an ordinance saying, hey, no more asking about salary history, because the statistics, the research shows that one of the greatest ways employers keep wages down, keep salaries down for women is to say, well, what are you making? And you say, oh, I'm making this. And then they say, okay, well, we're going to pay you this. And you accept that, not knowing that the guy that's doing the same dang job you are, because he never took time off to have children, never took time off to take care of 6 parents, or never got out of the workforce, he's making more money. So you end up with that salary history sort of embedded in the culture of how we pay women. So we passed an ordinance. It's now part of Chapter 38, which is the ordinance that Paul enforces. Employers in Kansas City, our great city, can't ask about prior salary history. And it can be a huge discrimination factor that's been eliminated with that. And we need to get the word out, so tell your friends. So that's about all I have to say, except file with the Kansas City Human Rights Commission or Department, Missouri Commission on Human Rights, the EEOC. They're all investigative administrative agencies. The law requires you to file with an administrative agency prior to getting what's called a right to sue letter and being able to litigate in court. There are certain time deadlines, so you have to file a charge. It's called a charge within 180 days of the last act of discrimination. Typically, there are some kind of, for race cases, it can be a little bit longer. And what I want to say also that people should know is a lot of lawyers in this field will, and I don't want to speak for Athena because I'm sure but they take cases on a contingency fee. So I feel like a lot of people are discouraged and they go and they think, oh, you know what? I heard that lawyer's making $300-400 an hour. I can never afford on my minimum wage job to pursue a sexual harassment complaint. Well, the lawyers that represent the people do it on what's called a contingency fee, which means if they can't win money for you, if they can't resolve the case with the settlement or through court, they don't get a fee. And that's really important. I think it opens it up for a lot more people to seek the advice of a lawyer. You just need to know who they are, and Rick is here, Athena's here. There's some really great plaintiffs lawyers in Kansas City. The other thing I wanted to say about the tax law before I lose my train of thought on that, attorney's fees are deductible if it's related to an unlawful discrimination complaint, and they're not in other kinds of lawsuits. So also should know that. And I think that's it. Paul, anything you want to say as an investigator, what people should know? Or Sure. Quickly. We're just trying to move. No, I mean, speak quick.
Oh, speak quick.
Yeah,
I'm sorry.
not long.
Sorry. Can you hear me okay? Do I need to be in there? Okay. My name is Paul Pierce. For the last 21 years, I've investigated discrimination complaints in the Kansas City Human Relations Department. 18 of those 21 years, I've focused on employment discrimination. And as Jane said, our ordinance is the city's equivalent to EEOC, you might say, in that we investigate complaints in race, gender, national origin, religion, disability, age, sexual orientation, and gender identity. We have to set certain guidelines for us to investigate complaints. The incident has to take place within the city limits within the last 180 days, does not involve another level of government or political subdivision, and the employer has to have at least 6 employees. So if you meet those 4 criteria, our department has the authority to investigate a complaint of discriminatory treatment. We try to complete investigations within 120 to 180 days, depending on how long it takes to contact attorneys or representatives, find witnesses, and that sort of thing. And we do the best we can. We need more people to come into the office to file complaints. A lot of times, they see these commercials that we run on Channel 29 and Channel 2, and yeah, that was me, and well, so much for that. But we do need people to come in to file complaints. It's one thing to have something happen to you and you stay at home and you talk to your family and your friends about it. It's another thing to have it actually investigated. We don't represent employees who file complaints or employers who have complaints filed against them. As an investigator, I'm neutral. I don't choose any sides. My job is just to gather evidence. And at the end of that fact-finding process, we make recommendations on what that evidence is and whether or not we can verify the allegations in the complaint. And then there's some other things that happen after that, depending on what that recommendation is. When we get to the point of questions, I'll be glad to answer any questions that you all have. So thank you all for having me.
Alrighty, thank you very much, everyone, because I think now we have a good overview here. Do people have questions? Because we've got some that are prepared. How many people are? Why don't we go with one on? We'll go with one that I was suggesting is probably some of the best that was prepared, and then we'll start going to here. The salary. Everybody talks about salary. Given that it is as Judy pointed out, we're an at-will state, most employees are. How would you actually go about finding out more in your workplace without the feeling like you're going to be threatened, then you're putting yourself out there as the person that's going to be given the axe or, compromised in your position, demoted or just put it in a real awkward situation? Does someone have an answer for that? Because frankly, that's one of the things that I hear a lot about conversations.
Well,
And just take them from there. We're not going to,
There's always power in numbers. And the best security is not to have the law on your side, but to have other people on your side. And so if you're going to talk about salaries, and if you're going to try to raise the issue of salaries, you better have some fellow workers who are also, wanting to do that. You don't necessarily have to want to organize a union as long as you're trying to organize around an issue. And so, be discreet until you feel like you have a number of people who are who have your back, basically.
Should you try and get people at different levels within the company?
It depends on what kind of company you're working at.
Okay.
The fact is, the most vulnerable people, the people with the least protection in a company, are supervisors. They don't have any rights. So, the workers have more rights than supervisors do, illegally. It depends on what your goals are. But certainly, talking to other people can get you a lot of information. And that's a very important thing to do.
I would just add that in this day and age, go on the internet, they have websites that they specifically look at job titles and pay scale, Glassdoor. There are definitely a lot of resources, a lot more resources than we've ever had to be able to look at pay disparities.
And I would also add that if you work for a governmental entity or a political subdivision, it's open records. They can't tell you that that's, and I will say personally, I work for the federal government, and they had a database that they had to publish every year, and by God, I found out that the guy that was doing the same job that I was doing was making $10,000 more than I was. And so that's a resource. I also think that the way you ask about things can give you some protection. If you say, I'm concerned that there may be pay disparities, and I'd like to know what those disparities, if they exist. So you're looking at it through a lens of discrimination, you're couching your language so that if they take an adverse action against you, you can then say it was retaliation because you were speaking up about what you perceived as discriminatory. Yes?
I'd also focus on pay disparities because of being a woman or because of color.
Right.
Correct.
Put a fine point on it so there's particular activity.
And document it. When you go to talk, go take a note on what you've said, who you spoke to, the time. I start in the Human Resources Department, and if they act like you are asking them for, trade secrets, then I think that's probably a pretty good sign that there's some issues there.
Yeah, one other point. Probably most of you have heard of the Lily Ledbetter case.
Yep.
The woman who worked for decades for a private company and found out that she had been systematically underpaid all of her career. And then she lost her discrimination case because the court said that she missed the 6-month filing deadline. And then Congress passed a law, the Lily Ledbetter law, which suspended that deadline. And so, the fact is that there's lots of historical discrimination against women in the workplace, and they're not going to tell us, so we got to dig it out.
So who pays the mediator?
Well, I think that can go a lot of ways. I mean, and it depends. A lot of times I won't go to mediation unless the defense is going to pay for it. If I have a good case, that's what I say. If I have a bad case, I'm like, yeah, we'll split the costs. We'll both pay. So, and it depends on who the mediator is. Some of them are very expensive.
What kind of mediator are you talking about?
You say arbitrators are typically paid.
Arbitrators are different, yeah.
That's different. But if the employer is paying it, then they're biased, so why do you have?
We're talking about arbitration.
Well,
Are you talking about mediation? Well, I think it depends on the
Explain the difference. Because
Well, yeah, Athena, you can choose the arbitration. I mean,
Well, I think that arbitration would be something where you're asking the arbitrator to make a decision. A mediation is a process where the mediator's entire job is just to try to see if the parties can make a resolution of the situation. So typically in mediator situations, that would be bargained for as the resolution of the case. Arbitrations, employers tend to pay for arbitrations, which does make a we call it a split the baby kind of thing, because the arbitrator wants to keep more cases, so they may tend to favor more companies. But then they also want to be used on the employee side as well. So it's a back and forth a lot with arbitrations. But yes, employers do pay.
Yeah,
But where
just
does
let
the
me add,
employer have-
that's not true for union arbitrations. In union arbitrations, they split it. Yeah, because otherwise they feel that they're going to be biased.
Well, I get why the arbitrator would favor the pay, but what did you say about the employee, why they?
So when you're in, the employee also would be represented typically by counsel. And so when arbitrators go into a situation, especially when you're in a market like Kansas City, not going to favor the employer or the employee. They're going to try to make some kind of resolution that would satisfy both parties to some extent.
You got to do some research on it. I've never agreed to a mediator that I haven't spent a lot of time calling other attorneys, asking about them, what's their history, where do they practice law, what kind of cases do they do. So
there's a comfort level with the
yeah, and sometimes the people that you think would not be very good or sympathetic to a plaintiff because they've done defense law all their lives, sometimes they'll surprise you, and people will come and say, oh my God, he bent over backwards to be fair to my client and not have a perception, So you just have to do some research.
Or what their specialty is.
Correct.
They also specialize in a certain type of company.
I had a question about that change in the tax law. Is this expense an itemized expense?
For the defendant or for the plaintiff?
For the defendant, for the corporations.
For the corporations, it is an itemized expense, yeah.
So in other words, there's two ways you could play a research game on this. Yes, you could go back to all the itemized accounts and find out what the scale of the discrimination was based on the amount that they're doing tax deductions on, right? Or you could compare their tax returns now that the law has passed versus the tax returns before the law was passed and compare the deductibles and see what the scale is.
That's a lot of research.
Yeah.
I don't know. And I don't know that you have to get somebody's tax return, they have to sign a release. So they may have something in their annual report that you could maybe go through it, but unless you're the CFO of a company, you're not going to know. I'm saying in the midst of a mediation, it used to be, you didn't have any leverage with these companies when they said, oh, we want you to sign a non-disclosure. We don't want you talking about this. And believe me, I'm in the middle of a litigation right now where my client's husband said something about the company and they're coming after her so now if you're in it, you can say, listen, I'm not going to give you that. If you want to waive your deductibility of these expenses and these attorney's fees, go ahead, but I'm not going to give you a non-disclosure with that extra money now. And they're going to see that they have to pay some money. I would say it gives you better leverage.
It seems like, to me, I actually wish I would have known about that a little bit more broadly because it would have made a great column, that it seems like, it put more of the impetus on the company not to just see this as part of doing business. So perhaps that will force them long-term to clean up some of the practices because you can't take the write-off for some of these things.
And what do you think the
Hopefully it'll
business
be a better
companies
world.
did, though? They went out and put it out that now you couldn't deduct the fees if you were an attorney,
Yeah.
which was not the intention of the law. So the IRS had to put something on their website saying, no, plaintiffs still can deduct above the line the attorney's fees. It's complicated tax law. Nobody wants to hear about that. But anyway, that did not go away. Plaintiffs still get to deduct the attorney's fees from any award that they get. But defendants don't if there's not a disclosure agreement.
Yes, it's for Athena. In what circumstances might a woman sue the perpetrator as well as the employer or instead of the employer?
So it depends on, the law has changed recently. So I will tell you that before the law changed, you could, if you had a supervisor that was discriminating against you, you were allowed to bring what we call individual liability against the supervisor. That has changed, and now individual liability is no longer under, at least in Missouri, you don't have that option. But let's say there are civil claims that exist, battery, assault, those are claims that you would be allowed.
When did that change? I mean, recently or 5 years?
Just a couple years.
Okay.
Was it 15? 2018. Thank you.
When they changed the clear and convincing and all that?
2017. August of 2017.
Senate Bill 43.
Senate Bill 43, I know it well.
Yes, this is for Kimberly. I'm interested in how your treatment on your work site has changed or stayed the same since you became involved and identified with the movement?
Okay. I mean, my treatment is pretty much the same because it's like a don't ask, don't tell kind of thing. Are you meaning like me being in the fight for 15 and standing pacing? It's kind of like a don't ask, don't tell kind of thing. You know what I mean? Like, I can tell my, like they said, I can tell my coworkers when there's less people around, people that I kind of bond with, and then I find out that we have similar interests and everything, like they're going through the same issues and problems that I'm going through, then that's when I introduce them to Stand-Up Casey and the 515 and the union movement. But yeah, it's kind of like if you don't know, I'm not going to tell you that I'm a part of it.
But do you feel that your direct supervisor or others that work with you know specifics of your involvement?
Yes, I've had a few cases who actually found out that I was, leader in the 515 in a union. But it's kind of it's more complicated. If they don't hear me talking about it, it's like they can't approach me and ask me about it. You know what I mean? It's like if you hear me talking about it, then you can say something. Most likely, probably. But no, they can't. Okay. But yeah, they can't do anything to you for it at all. But the better time would be after work or out like on break time or something like that. That's normally when I would do it.
Thank you.
Kimberly, can you tell us why that book is in front of you?
This book is in front of me because I actually had the honor and opportunity to be a part of it and be in it actually. I met some really, really great women. Gwyneth Paltrow was in it. Ashley Judd's in it. Can I see it?
Yeah.
I see the names.
I'm looking your name up in this.
Oh, yeah. And she told me earlier that she realized that I was quoted actually quite a few times, which is great. I'm glad that I was quoted quite a few times because things like this do need to be heard and seen. But the authors are Judy Cantor and Megan. The book is called She Said, and yeah, it was a really, really great opportunity. It's a really great book. If you guys love reading, I feel like you guys should get a copy. Or she called me a celebrity. I don't want to say I'm a celebrity. I mean, I've only been able to do this with the support and the help that I've received from women who've experienced the same thing I've experienced in my 5 for 15 family. I would have never had the opportunity to do this without them. So, yeah, I don't want to take all the credit. It's not me, it's us.
Just a quick follow-up. Has McDonald's followed up with you? Has there been any progress with the company or?
There's some things that you can't talk
Yeah,
about.
I understand.
They're in litigation.
I understand. Thank you.
I have a question. Is it a norm for, or maybe nowadays, for companies that they would change the description of the job and they let go of the people and they have to bid back for actually it's the same job but it's a different description. So the employees are let go and they have to apply back.
Is that common?
Is that common?
Yes, and it is, but it's nothing new. I mean, they've been doing this for decades to either get rid of, basically to cut pay and benefits for people. You know, if there's a group of employees whose pay they consider to be too high, often they do things like this when they're bringing in some kind of automation, new machinery, or something like that. They will do that. If you have a union, that is all negotiable.
Yeah, because if you're you can't be in the union. I have a situation that happened to me that the job was posted at a higher starting level, but they offered to me about $3,000 less than what was posted on the job posting. So I asked them why. They said they made a mistake. I said, no, it can't be a mistake because you posted it.
Is it a job that only you had, or were there other people who had the same job?
No, there's other people that has the same
And
job,
what were they paid?
higher than what I'm making.
Oh, okay.
So
Were they
and
men?
no, it's the women, but at the same time, the requirements is you're supposed to have a college degree. And I have 15 years of experience. My counterpart is a senior level when she doesn't have a college degree. And so when I came in, I asked the human resources, they told me it was a mistake. And I said, because I came from a lower level position just to get my foot at the door. And when I saw the opportunity, I bid for that position. And when they didn't give me the starting salary, actually, they lowered.
So the only thing I can say to you, and this goes back to how our labor laws suck, okay, is that if you could prove that the reason why your pay was less was either because of your race or your gender, then you would have something. Otherwise, they have every right to do that. You know, now if there were men and they had made higher salaries than women, that's something. There's a law called the Equal Pay Act. But otherwise, nope, sorry. Organize.
Thank you. And learn more by coming to things like this first, so thank you for the question. Yeah.
Somebody mentioned regulation and statewide regulations about forgiving or not making non-disclosure legal. Could you comment more on that? Remedies
Athena did.
around non-disclosures, capture?
So different states are enacting legislation to deal with non-disclosure agreements and confidentiality and how that would work. California is the most progressive of that legislation, and I believe when I was preparing for this, I looked through it, and they've made great strides to prevent non-disclosure agreements related to sexual harassment cases. So yes, there is legislation that is going in multiple states to help protect victims of sexual harassment from having confidential agreements.
In Missouri?
I've not seen such legislation in Missouri as of yet.
Yeah, not likely for an administration.
There are about 45 more states to go first.
Yeah, exactly.
Yeah. Did anyone else have one? Because I think we're about to the point where we need to start
Yeah,
wrapping
everybody
up.
has his hand up.
Athena, can you go and explain the relationship between an arbitrator and the judge?
Yeah.
Sure. So an arbitrator acts as a judge in certain situations when there would be arbitration that would be compelled. So the arbitrator acts as the judge in making decisions on admissibility of evidence and ultimately making the decision as to the result of the case. So an arbitrator is a judge in that situation.
And how does an arbitrator, how does that case get labeled as that, where the arbitrator gets to be the judge?
It would depend on if the arbitration agreement is enforceable, and if it's enforced, then there are certain programs like AAA, there's multiple programs that administer arbitrations, and an arbitrator would be selected by the parties.
Okay. But if he's not the judge, then the arbitrator, then that has to be submitted to a judge.
So you either go arbitration or jury trials.
Okay.
You're not going to have both.
Okay.
Anyone else?
Can I say something about arbitration?
Go ahead.
Okay. This is my understanding, and correct me, Athena, if I'm wrong. Companies use arbitration in order to avoid the law. Especially, like, say you have a situation where, there's some kind of mass discrimination. They have an arbitration agreement, and I know there's a thing about class actions and stuff like that with arbitration, and basically, if you're under one of these arbitration things, you can't go to the courts, which means you really don't get the benefit of the law, you just get an arbitrator who may or may not actually even obey the laws, who is making the decision. Is that correct?
Yes, I mean, that is correct. It is a way to avoid the jury system. And I think that one of the reasons that it's avoided is because it minimizes their exposure, the company's exposure on that. And so an arbitrator is less likely to have a huge punitive damage award when an employer or business does something really wrong. So yes.
I see it as part of actually a worldwide phenomenon of privatization and the removal of corporations from having any kind of accountability for the treatment of their workers. And we see it in outsourcing, we see it in offshoring, and we see it in the avoidance of actually coming under the jurisdiction of courts through these arbitration agreements. And I know the Supreme Court upheld this in a recent decision last year or the year before. And people really need to understand that it is part of the growing power of corporations to avoid any kind of accountability.
And so you said, so that your exposure, you were referencing financial exposure, but it's also publicity exposure too.
Correct.
Yeah. Right, so we don't find out that XYZ Corporation just killed, a worker or whatever, or is a systematic harasser or whatever.
And Athena, doesn't the arbitration agreement actually state, I waive my rights? In an arbitration, I actually waived my rights, my legal rights and the law, rights of the law.
You're actually agreeing to the arbitration, and you're not saying that I don't get any rights under the Missouri Human Rights Act or Title VII or anything like that. You are not waiving those claims. You are just agreeing that will be a separate forum to get your complaint of discrimination.
Now, let's go back to Judy's question though, because I'm not clear yet. In an arbitration, is the arbitrator bound to abide by existing laws that pertain to the case?
Yes, the arbitrator should be enforcing the law.
Okay, thank you.
But there's no way to appeal or contest that if you believe that he or she did not.
No way is not entirely correct, but it is very difficult to appeal.
It has to be arbitrary and capricious. It's a very high standard. You have to basically prove that the arbitrator was way out of bounds, and that's not typically something that's going to happen.
And you have to prove that to whom?
You would file a lawsuit
Against
the company and the arbitrator, I would. But it doesn't happen very often.
Because hopefully you've agreed ahead of time that this is the process.
If you have to go through arbitration, it's something you're going to want to say, typically you get to negotiate who your arbitrator is.
Yeah.
So you're going to say, no, I don't want that person. He's got a horrible reputation, always fines for the company. No. So there's some give and take in that, but it is a limitation. Like Athena said, most arbitrators, just like if you try a case to a judge, it's disimpassioned. They're going to be much more, what are the facts? Oh, I don't care if this caused you couldn't sleep. They're not going to give you punitive damages, where a jury is going to sit there and say, wow, you went through hell and back. You deserve a lot of money for the way they treated you. That's why plaintiffs' lawyers want to get to the jury. That's why arbitrators are cool negotiators. They know how to be disimpassioned, cool cucumbers. And so that's and the employers know that. And their sell to their board of directors it saves us tons of money. We got to go litigate this case and pay for depositions and experts. It's hundreds of millions of dollars sometimes. But if we go to an arbitrator, oh gosh, maybe we don't even need to take depositions. Maybe we'll just go in there and kind of argue our case.
And there's essentially no appeal process, or not much of an appeal
Not-
process like there is in a
Correct.
regulatory trial.
So I got another question then. So what's the procedure if you're going to arbitration? Do you hire your own lawyer? Does that lawyer present the case at arbitration? And you have to pay your own lawyer?
Well, I represent people at arbitration, so.
You do, yeah, okay.
And there's sometimes where I don't know necessarily that an employee has an arbitration agreement. Sometimes you don't hear about it until the lawsuit has already been filed, and there's something called a motion to compel arbitration. So, but yes.
So you're representing this person and then you find out, no, they've said.
That
But then
happens.
you argue the case in arbitration then?
Absolutely.
And that happens probably a lot because people start jobs, sign a lot of things electronically. Sometimes they don't even have copies of it. 10 years, 15 years down the road, you know, something happens.
Or particularly if they're a younger worker. I mean, I've
Correct.
often found this. It's the older workers that sometimes figure out, and younger. I mean, the thing that they say about millennials is that they'll, you know, frankly, and I've had this happen in my family, you know, they'll just leave and go find another
Right.
job
Yeah. Exactly.
rather than try and fight something.
Correct.
So anyway, I really appreciate all the questions and definitely the panel. I think we're about out of time here, so we want to wrap up. We have Ms. Shores.
I'm Joni Shores, and I'm with the American Association of University Women, and also with the Women's Equality Coalition, two really exceptional groups. And I think, first off, we need to give a hand to this marvelous forum and Mary Sanchez. I hope it's been as enlightening an evening for you as it has for me. So I want to thank you on behalf of AUW and WEC for coming this evening. And I'll point out to you that on our table out here, we have some excellent flyers. One of them that I'm familiar with is called The Simple Truth, and it's research. It's based on research about what women are making now as compared to what men are making on the same jobs, apples and apples. And that's a real eye-opener. There's also another pickup on the Work Smart program. And I really would like for you all to take one of those because it's an online program that you can use to negotiate your salary. So I hope that's helpful to you. And if the panel would stick around for just a few minutes, just in case we have some more questions. Thank you so much.